And then they give this sort of limp-wristed assurance like, well, we're not interested in that, so that's not really a problem. Well, it is a problem when you just get to pick and choose what collectibles and what commodities you're going to decide one day that you're going to regulate.
Hi, everyone, and happy Friday. I'm Andre Bagansky coming to you live from our snowy Brooklyn studio. On the show, we have Bill Hughes today, Senior Counsel and Director of Global Regulatory Matters at Consensys. Jumping right into things, Bill, what stood out to you during these 4 hours of testimony during this Coinbase hearing that happened the other day?
The big substantive issue is that whether tokens are securities, especially for secondary trading, is the big issue in this case. And the judge may feel that that issue is something for her to render an opinion on in the coming weeks and months, because that's what Coinbase is essentially asking her to do. And if you listen to the court's questions and the types of points made by both sides that the court's really focusing on, it looks like Coinbase has a pretty good shot to getting an answer that would not only be good for Coinbase, but the entire industry.
We'll get into some of these victory odds that are floating around later. But, just to catch people up, for those who aren't aware of this court case, the SEC sued Coinbase in June, essentially saying that the exchange failed to register with the regulator before it started offering its customers trading and staking. It's said that at least 13 tokens that are available on Coinbase are securities. Could you just clarify what's at stake here for Coinbase as a company, these token issuers, who it's worth noting are not on trial in this case, and also the crypto industry at large?
So it's essentially Coinbase's, the meaningful part of Coinbase's business is at issue in this case. They're essentially saying your entire trading platform that everybody associates with Coinbase is an unregistered securities exchange, and you need to shut it down. It's also saying its staking offering is an unregistered securities offering and needs to be shut down. It's also saying that Coinbase Wallet, which is a self-hosted wallet, is an unregistered broker and either needs to be registered or needs to stop being offered to people. So Coinbase has diversified its business over the years, but this is like the core of what they offer. So it's hugely important that this come out in a good space, in a good way for Coinbase. But while the case just involves Coinbase and the only remedies that the SEC can get are against Coinbase, the outcome will implicitly dictate what is inbounds and what is not for crypto, at least in the United States. These questions are always facts and circumstances determinative, but if a court says offering a centralized crypto exchange in the United States is illegal unless you're registered with the SEC, that sort of is pretty clear to every other centralized securities crypto exchange. It's at least what one court thinks of that issue. And so it would have huge ramifications. I think really, and I'm from Consensys, we offer MetaMask. We are in lots of different software offerings attendant to the Ethereum and other programmable blockchain ecosystems. A big part of this case that we really care about are the parts that really don't deal with the centralized exchange platform part of it necessarily, but have to deal with the unhosted wallet part and the staking as a service part. These parts of the case obviously impact us. Our MetaMask offering, MetaMask is the leading self-hosted wallet in the world. We're looking very closely at what the court does with the unhosted wallet, the Coinbase wallet part of this case, and what the court decides with respect to the SEC's assertion that helping people stake their own tokens is a securities offering. We have that really impacts staking generally, and certainly impacts staking offerings that we provide. Although ours are different, and so it's going to have huge ripple effects. However this case pans out, it's going to have huge ripple effects across the crypto industry in the United States. And so it's really important for everyone that the court gets it right.
Yeah, talking about some of your notes before we began the show, one of the things that you seemed to indicate was that Failla really was looking closely at this staking issue and really didn't seem to
Mm-hmm.
like sort of buy the SEC's argument when it came to that, or at least wasn't that enthusiastic about it. Could you opine on that a little bit more and just sort of tell us what you saw?
Sure. She said very clearly that she looks at it at staking as a mechanism and says, this doesn't strike me at all as investment. Well, it's the least investment like activity out of anything alleged in the complaint, which is correct. Like, staking is a data integrity mechanism. It is the method through which you can decentralize the process of maintaining the ledger and updating the ledger. It is a technical process that is essential to the consensus mechanism of the system. The SEC says we don't care. You make money doing it, and therefore we can squint our eyes and turn our heads and say it looks like an investment scheme, so we're going to call it that. And you're going to have to ask us for permission to do that in the United States. The disagreement is whether what Coinbase has a custodial staking service. You give them tokens, they put them in a validator for you. The validator spits out rewards because that's what the protocol offers: rewards and in transaction fees. And you get that compensation for the work the validator is doing, and you get to participate in that because you're putting up some of the collateral that's at risk for the validator misbehaving or failing in some degree. We view that, the ecosystem views that as providing technical services on the part of Coinbase. Just like when you run this podcast, anybody basically runs a business. You likely don't have your own servers anymore. You likely farm that out to AWS or someone else. They're providing technical services which are required for you to offer the service or you to do your business like you're doing. You to engage in the activity you're doing. Same thing with Coinbase. Same thing with Consensys staking. We are offering a technical infrastructure which permits you to engage in a data integrity mechanism for the network. We are not engaging in managerial or entrepreneurial things which could be considered investment activity for purposes of the securities laws. I think Judge Failla sees this, or she very strongly suspects it, and I view it as by far the weakest part of the SEC's case. Whether or not she can reach this issue at this point in the case comes down to whether she views there as there being potentially facts that need to be developed that bear on this question of whether or not this activity is truly just administerial technical or whether there's some entrepreneurial managerial aspect of it. If she believes that some facts do need to be developed to dispose of this issue, to decide it, then she can't rule in favor of Coinbase now. She would reject their motion. She would deny their motion as to the staking claim, saying, I just need more facts here. That doesn't mean she isn't strongly leaning to where like she thinks the case is going to play out with respect to staking. She just can't get there yet because there's the record isn't complete enough for her to rule on the issue.
That's a really
We'll
interesting
see.
point on. Sure. On that matter of staking, it's something like as people are really fixated on the potential prospect of an Ethereum, a spot Ethereum ETF this year,
Mm-hmm.
I personally wonder how staking is going to fit into all of that. But, Texas, let's pull up A1 if you could, please. Bloomberg Intelligence has penciled in 70% odds of victory for Coinbase, which is not as bad as a coin toss, but it's unlike some of these Bitcoin ETF odds we saw a couple of weeks ago. I mean, how does that 70% figure from Bloomberg Intelligence align with what you're seeing in this case?
So 70%, I think that's fair. I tend to not quantify the chances of things like this. I would say, first of all, it's not an all or nothing proposition, right? Like, the court doesn't have to grant the Coinbase's motion to dismiss everything that the entire complaint. She doesn't have to grant everything that they're asking for. She could also deny everything She could grant everything or she could deny everything. I think it's probably going to fall somewhere in the middle. I think there are going to be some issues that she thinks no facts need to be developed. I only need to decide a question of law to determine whether or not the SEC wins or Coinbase wins. And if she, on certain issues like, does trading a token, could trading a token on the secondary market be a securities transaction? That could just be a question of law where she could just decide it now. And if she does decide it's a question of law, then she's going to go into the case law and figure out, from her perspective, what does the law say about that? And if it is not a securities transaction, that's it for basically the entire case, but the staking question. Everything gets dismissed. Coinbase wins on everything but the staking issue. But if she decides that in favor of Coinbase, I would think that she would decide the staking issue in Coinbase's favor as well. She could alternatively just decide there are too many questions of fact on other things, but on the staking issue or on the wallet issue, this is ready for me to decide. And she can just decide it as a matter of law. I think it's more likely than not she will decide some issues, but not all issues. And whether or not those issues come out in Coinbase's favor or not really depend on the issue. I do think on the merits of certain arguments, Coinbase has a much better position, and that the SEC's position, especially on the biggest issue in the case, is utterly untenable. And the court has sort of indicated that she's very troubled with their interpretation. So as a general matter, I think it looks very good. If you're going to roll it up into one single number, 70%, sure. But that 70% doesn't mean that this motion means that the case goes away. It could be 70% that at the end of, when all is said and done, Judge Failla agrees with Coinbase. But that could take a very long time to play out.
We're gonna touch on some of Coinbase's arguments, especially the major questions doctrine towards the end of the show, because I do find it interesting here. But I want to take a step back and talk about case law within the Southern District of New York. When I think of crypto cases that we've seen recently, three really come to mind to me. We have the Ripple Labs decision from earlier this year, which was overseen by Judge Torres, and then we have Terraform Labs, which was overseen by Rakoff. And then, of course, we have the Uniswap case, which was overseen by Failla herself. And for me, like going into sort of the filings there, it was really interesting to see just how much of an understanding Failla has of this tech, and how much parsing the code of how liquidity pools work and who's responsible for what, for me, was something that I hadn't seen before as a judge. But, I've got three questions for you here. Would love to see you just work through it at your own pace. But on my mind, I'm wondering, how do all these cases mesh together, and where do the judges seem to stand on these issues? And how have you seen what's come up in those cases sort of inform the legal strategy of both Coinbase and the SEC?
So there's a bunch there. You may have to refresh my recollection as to all the questions. But the first thing to understand is that these judges are all sort of peers, and they can look at the opinions at other opinions that other judges issue, and they can look at them and decide, does this persuade me to think a certain way? Nobody has to follow the lead of any other judge at this level. So that's the first thing to understand. I think when you look at the Ripple and Terraform Labs cases, those are very different from Coinbase in an important respect. Coinbase's case, the big part of Coinbase's case, the front and center part, is about secondary trading in tokens. Coinbase does not issue any of these tokens. Ripple Labs and Terraform Labs were accused of issuing without registering a crypto security. That is not what Coinbase is alleged. And this is important because the Howey Test is really only applied toward issuers. You, issuer, actually offered people an investment contract without registering it first with the SEC, and you needed to have it registered. Howey, and Coinbase was making this case, really is never applied in the case of you, third party, that really has nothing to do with these assets. You didn't issue them. You're not promoting them. You, third party, are merely offering a mechanism for people to buy and sell them. So it's very different. The Coinbase case is very different in that fundamental respect. And so the question becomes, does Howey, which clearly applies in the issuer context, does it apply? Can it, with equal force, in the secondary trading context? I think where these courts come down as to the substance of Howey is very interesting. Judge Torres was asked to look at particular transactions and ask if those transactions were unregistered securities transactions under the federal securities laws in the United States. Um, and she determined that she bucketed them in the way essentially the parties indicated she should, and she found that some were and some weren't. Rakoff took and a lot of people have a problem with the way she did it, but I don't think what she did was incorrect or as a matter of law or approach at all. Rakoff did something different. He said he didn't look at a transaction by transaction basis, but he looked back at case law that says an investment contract is a contract or it could be just generally a scheme, and said, with respect to the tokens at issue under Terraform Labs, it's all part of a big scheme by Terraform Labs to essentially sell tokens and raise money, and view this all as a investment scheme. My problem with Rakoff's approach is that what precisely defines the scope of a scheme, as far as I can tell from his opinion in the motion in his opinion on the summary judgment motion in that case, doesn't create any sort of guidelines for how broadly you can look for facts that constitute a scheme. And this is precisely the approach that the SEC is taking. They're saying, well, it all has to be just part of the same scheme, and as long as you have a scheme and some marketing of it and somebody buys a token, that's enough for it all to be an investment contract, and that you can't do anything with the token. It's kind of made up. And I think the problem Judge Failla has with that approach, although she recognizes Judge Rakoff as being a brilliant jurist, especially on securities issues, she is very troubled that this way of looking at the issue doesn't have any meaningful limiting principle as to what in this context could be considered an investment contract. And in fact, what beyond this context could be considered an investment contract. She's particularly interested that any collectible or any commodity could, if you accepted the SEC's view and probably Rakoff's view as to what could be deemed an investment scheme and thus a security under an investment contract analysis, anything could be a security. And the SEC then is just can regulate anything that people buy with the hope that it goes up in value. And that is clearly much farther afield than the SEC's authority gives them purview to regulate. And what Coinbase has done in this case, I think very smartly, is give Judge Failla a way to think about the SEC's authority, which has some limits to it. And I think they have the better of the argument. The trick with Coinbase is getting the judge to adopt their view, which is a new formulation to some degree as to what this rule, which has been around for decades and decades and decades, actually means.
Well, I appreciate your clarification about this being like a case that really is focused on the secondary sales of these crypto assets. And, before we jump into the major questions, Doctrine, I just wanted to give you the opportunity because, of course, when we talk about collectibles and the concern there, I'm seeing people talking about Pokemon cards and Beanie Babies on my Twitter feed, and those being examples of sort of, I guess, markets that the SEC could sort of want to regulate if Failla sort of agrees with what they're arguing. But, on the topic of Twitter, I just wanted to give you an opportunity to sort of call out anything that you're seeing in terms of just maybe being taken out of context or is kind of missing the ball in terms of its accuracy when it comes to commentary on this case.
Sure, I'll definitely answer that. But just on the collectibles and commodities thing, the SEC sort of waves its hands at this argument like, oh, well, no, these commodities, these collectibles, they're not part. They're it's different, and they can't explain why it's different. And then they give this sort of limp-wristed assurance, like, well, we're not interested in that, so that's not really a problem. Well, it is a problem when you just get to pick and choose what collectibles and what commodities you're going to decide one day that you're going to regulate, and that everybody understands that's a problem. The SEC, engaging in grotesque self-help, says no, it's not a problem because trust us. Um, what interestingly Judge Failla and Coinbase really points out is that if the SEC's interpretation of their own authority as to what is a security in the collectible and commodity space is correct, then it's not just them who gets to bring cases. There are private rights of action under the securities laws. Anybody under in the right conditions can sue over the sale, the disposition of a security that wasn't registered. You just saw Uniswap get sued. The suit was dismissed by Judge Failla. Uniswap was sued under a private cause of action under the securities laws. The SEC is opening a huge can of worms by saying, well, everything is a security when we say it is under this theory, because now you're opening it up to utter chaos in private civil actions under the securities laws under this theory. Judge Failla recognizes that. That's incredibly important. The SEC should be admonished for not taking this issue more seriously. Back to your question. Back to your question about what do you see on Twitter. I just want to remind everybody about the posture of this case and what the hearing is about. This is an important motion in that Coinbase is saying, let's accept every single fact in the complaint as true. You have enough, judge, to decide whether we, Coinbase, or the SEC wins the entire case. We don't need to engage in any fact finding. There's enough there. You accept all of it's true. Coinbase says we win, and that's not really typical in litigation. So it's an important motion. The hearing itself, the purpose of it is to really do two things from the judge's perspective. First is she has to determine whether these issues need any more facts to be found before she can actually rule on the ultimate questions that this case raises. And the second thing she has to do is really say, do I understand the arguments of these parties? Do I really know what they're getting at? Do I really understand their reasoning? And so during the hearing, she can ask lots of questions. She can take positions. She can say things to prompt an exchange of ideas between the court and the party to really get at, like, what are they saying? What do they think is important for me to understand about their position, so I can later go and make a decision? Maybe she's close to making a decision. Maybe she feels which way she's leaning, but she wants to understand that she, one, is in a position to actually make a decision in this case, and two, understands what all the arguments are. So you see people in real time reacting to what's going on in the hearing, and both lawyers and non-lawyers are in some instances way overreacting to things she says from the bench, things she may be paraphrasing from someone like Senator Lummis, who presents her with a letter taking certain positions in that letter, and she may repeat those positions in the live courtroom to get the reaction from the party. And people listening to it go nuts on Twitter being like, she agrees with Senator Lummis that blah, blah, blah. It's like, whoa, hold your horses. All of this is a very careful, very earnest exercise to ensure that she understands whether, one, she can get to the merits of the arguments, and two, she understands both sides sufficiently well that she can come to her own decision. All that being so, let's not read too deep into it, and let's not all become touts and start betting on what she's going to do on this, that, and the issue. I think to some degree that's a waste of time and not particularly productive anyways.
Well, thanks, Bill, because I think in an engagement-driven platform, sometimes people get over their skis with hot reactions and hot takes. So really appreciate it.
It's definitely true. I will say this. I do think it does give you insight into how she's thinking, and I do think that's important. And I think the fact she was so skeptical and pushed back so hard on so many things the SEC was saying, I do think that is definitely indicative of where she is and the weakness of some of these SEC arguments.
Sure, definitely in terms of like where her scrutiny goes. But, I wanted to pull up, if we could pull up A2, please, Texas. I wanted to touch on the major questions doctrine. I've been teasing it throughout the show. We've got a nice story here from Fortune. But, I'd be curious to hear your opinion on why, Failla appeared hesitant in this situation to apply the major questions doctrine. And you're hearing a lot about it lately in admin law. So
Yeah.
would just love to hear your thoughts on this.
So what is the major questions doctrine? It essentially says the policymaker in the United States is the United States Congress. They give essentially policy direction to agencies, and the agencies implement that policy and fill in the gaps. What agencies cannot do is take it upon themselves to decide major questions of policy and then construct a regulatory scheme around it and then go implement that regulatory scheme. Major questions that impact the economy, markets, these are things left to Congress. It's been the argument of the crypto ecosystem for a while that crypto is new. Digital assets are not something contemplated by securities laws made in the 1930s, nearly 90 years ago by now. And so it's not just finance that crypto ecosystems are about. It's about more than that. And therefore, really, to regulate the space, Congress has to express through past legislation signed by the president what the policy of the United States is with these things. Where that is clearly applicable is if the SEC tries to promulgate rules like they did over the last couple years, where they want to classify DeFi protocols as securities exchanges for purposes of the securities laws. The argument there is like, no, you're just making up policy. It's really Congress hasn't given you authority to do this. So you don't get to promulgate rules doing this. The question is whether major questions doctrine really applies in the enforcement context. Coinbase argues it does. There's reason to believe it does. The pushback here from Judge Failla and the SEC, quite frankly, is Judge Failla says, I never see this argument being made in other securities contexts. There are plenty of contexts, not even in securities enforcement, but in other enforcement contexts where nobody's saying you don't get to even enforce in this area because you don't get to have any say as to what the law, as to what federal law dictates in terms of market behavior in this area. She's like, I just don't see this as an argument in any being brought by securities defendants before. And that signals to her that it's new. And so she's being very cautious with it, a little bit suspicious of the argument. The SEC says, Your Honor, this isn't major questions doctrine case, because what are we doing? We are looking out into the broader markets and saying, in what instances is someone offering an investment contract that isn't registered? And that is squarely within the SEC's jurisdiction to do. We do it in every sort of subgenre of the broader economy. We do it in real estate. We do it in beaver pelts. We do it in every context you can imagine. This is just another context in which we're saying the test in Howey is satisfied. Therefore, we have an investment contract. Therefore, you need to register it. So there's nothing new here that we're doing. And the case lives and dies on the Howey test. So we'll see what the court does with it. I think the court definitely did express some meaningful suspicion. Major questions doctrine, I think to some extent in the ecosystem, crypto ecosystem has been seen. Maybe this is the silver bullet, which gets the SEC out of our hair. We'll see what the court does with it. But the court's posture, her tone, the question she was asking on Howey generally and on other issues was a lot more heartening for the ecosystem than it was on the major questions doctrine. That's for sure.
Yeah, I'm definitely, it'll be interesting to see like when we get this decision from Failla and what it comes to and whether or not the case moves forward. But, teasing ahead to some of our interviews that we have upcoming, we're going to have SEC Commissioner Hester Peirce on the show. And I would love to just know what's on your mind and what kind of question would you pose to her that's related to this case?
So Coinbase went to great lengths to engage the SEC to try to work with the SEC to come up with a regulatory framework through which the SEC was satisfied that Coinbase's business sufficiently protected consumers, investors, the public at large, broader markets, and that Coinbase was doing what it needed to do. Those efforts on the point of Coinbase were drew out for a long time and were eventually rebuffed shortly after, famously, right after the FTX collapse, when it's presumed that Chairman Gensler decided that the SEC's posture on this was going to be meaningfully different than it had been for years, and that the time for talk was over. My question for Commissioner Peirce would be, if there are like 2 or 3 things that she would expect the SEC to be doing now if we were under normal order, and maybe we will be doing in over a year from now, assuming Chairman Gensler moves on from his post, what are the things that we could expect the SEC to be doing that would make the situation better that we aren't doing now? I'd be really interested. I think she's spoken on some of these points before, but we need to start thinking about a more productive engagement with the SEC, whether dictated by a change of leadership of the SEC or whether dictated by some of the legislation that's currently before Congress. Because the status quo is not going to be forever. We're going to be moving to a more productive time where, in the end, we're going to actually reach a state that is better for U.S. persons, both investors and non-investors.
Well, I think that's a fantastic place to leave things, Bill. And, I really appreciate your time and coming on the show and being very generous in terms of helping listeners hopefully catch up and understand the nuance that's associated with this case. I guess that'll be it for me from Andre Bagansky at Coinage. Bill, I hope to have you on the show soon.
It was fun. Thank you for having me. Have a great day and weekend.
Thank you. Enjoy that snowy weather. Well, that's going to be it, everybody. I hope you have a good weekend, and we will see you on Monday during our usual news recap show. I'm Andre Bagansky. Have a good one, and take care.